Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 30th to May 4th, and today is May 7th, 2018. Two trading firms within a group structure were fined $2 million in aggregate by the Commodity Futures Trading Commission for alleged violations of various provisions of law and CFTC rules, including purported speculative limit violations related to their cotton futures transactions. Separately, the conviction of a former trader of a major investment bank was upheld for misappropriating his former employer's source code for algorithmic trading. Finally, a class action lawsuit was filed against Ripple and its chief executive officer, claiming the defendants were engaging in a continuous unlawful offering of an unregistered security, the XRP digital token. Last week was the 40th annual FIA Law and Compliance Conference in Washington, D.C., and I was energized by the outstanding panels. This week, however, I desperately need to catch up on work and attend a number of social and charity events. So I can get going. Let's get started. Glencore Grain BV and Glencore Ltd. collectively agreed to pay a fine of $2 million to settle charges by the CFTC that from January 2013 through November 2015, they violated various laws and commission regulations related to their trading of cotton futures on ICE Futures US. In particular, the commission alleged that the firm violated speculative position limits on multiple days in May and June 2013 and again in May and June 2014, entered in exchange-related position transactions with each other contrary to IFAS rules, and thus prohibited by law and CFTC rule, and failed to file two reports with it of their physical cotton positions that were accurate as of the last day of May 2013 and May 30, 2014, as required. Interestingly, in May 2016, Glencore Grain agreed to pay a fine of $200,000 to settle charges by IFAS that, on May 30th, 2014, a day within the time period identified in the CFTC settlement, the firm may have violated position limits in the July 2014 Cotton No. 2 futures contract. In addition, alleged the exchange, the firm may have caused quote-unquote price movement in the relevant futures contract and a corresponding July-December 2014 future spread when the firm, quote, waited until the final 20 minutes of trading to execute a high proportion of their transactions on the day prior to first notice day, end of quote. Was this vague reference something behind the CFTC enforcement action? New York's highest court, the New York Court of Appeals, upheld the conviction of Sergei Aleynikov, a former computer programmer for Goldman Sachs & Co., who was charged in a state court in 2012 with illicitly copying and using for a new employer, Tesla Technologies LLC, Goldman's proprietary computer code for a high-frequency trading system. Mr. Aleynikov was initially charged by a federal grand jury for a violation of a federal law related to his alleged misappropriation in July 2010 and found guilty by a jury in December 2010. However, the Federal Appeals Court in New York overturned Mr. Aleynikov's conviction in 2012, concluding that source code was intangible property and not a good, and thus a theft of computer code could not involve the quote-unquote taking of a physical thing, a necessary requirement for a violation of the relevant federal law. Mr. Aleynikov was subsequently criminally charged and convicted by a New York court jury for violating a provision of New York law that prohibits a person from making an unauthorized tangible reproduction of secret scientific material. However, the New York trial court set aside the jury's verdict, claiming that source code is not tangible when it is only stored on a computer. In 2017, the Intermediate Appellate Court in New York reversed the trial court's order and remanded the case for sentencing. Acting on Mr. Aleynikov's appeal, the New York Court of Appeals upheld the defendant's conviction. The New York Court of Appeals said that a quote-unquote rational jury could conclude that the copy of the source code made by Mr. Aleynikov, quote, was tangible in the sense of material or having physical form, end of quote. This is because the jury heard evidence that, since source code stored on computer takes up space on a drive, it is physical in nature. As a result, the court upheld Mr. Alenikoff's conviction. And finally, a purported class action lawsuit was filed in a California court against Ripple Labs, Inc. and other defendants for offering and selling unlicensed securities, namely the Ripple digital token, XRP. The named plaintiff, Ryan Coffey, seeks rescission and punitive damages against all the defendants, who also include XRP2 LLC and Bradley Garlinghouse, the chief executive officer of Ripple. According to the complaint filed in this action, all 100 billion XRP tokens currently in existence were created by Ripple Labs in 2013. 20% of these were allegedly given to individual Ripple Lab founders, while 80% were retained by Ripple Labs. The complaint alleges that the defendants have steadily sold off their XRP over time, quote, in what is essentially a never-ending initial coin offering, end of quote. And XRP tokens offered and sold by defendants, quote, have all the traditional hallmarks of a security, end of quote. This is because purchases of XRP tokens represent investments in common enterprise with profits expected through the efforts of Ripple Labs. Because of the restrictive governance of Ripple Labs, the XRP distributed ledger is also a centralized ledger controlled by futures persons, as opposed to a decentralized ledger like Bitcoin or Ethereum, claims the lawsuit. Ripple Labs and XRP2 were collectively fined $700,000 by the Financial Crimes Enforcement Network of the U.S. Department of Treasury in May 2015 for facilitating transfers of virtual currency and providing virtual currency exchange services in connection with XRP without registering as a money service business and not complying with anti-money laundering requirements. Previously, the CFTC has suggested that both Ether and XRP are virtual currencies in a lab CFTC primer on virtual currencies. Moreover, FinCEN in its lawsuit against Ripple Labs and XRP2 not only referenced XRP as a virtual currency, but in fact grounded its lawsuit on the defendants' exchange activities involving virtual currencies. We'll see. This is a current debate that's also going to be sounded out in Washington, D.C. apparently next week between the SEC and the CFTC. A very important debate. Well, that's it for this week's edition of Bridging the Week. As always, there is more information and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.